I'm delighted to be able to intervene on this subject. In fact, I was reminded by one of the panelists, Daniel Gumi, yesterday that we spoke about the Mauritian Kenya DTA many years ago, because as some of you who would have been following this subject for many years, we did have an aborted Mauritius Kenya DTA many years ago. And we did think that we probably would not see a Mauritius Kenya DTA during our lifetime. We are now well on course to have a Mauritius Kenya DTA fully in force. And the panelists later on will be talking about the history of that treaty, and also will let you know where we currently are in terms of its effective implementation. I thought it would be good to provide just a quick synopsis of what a double taxation agreement is for the benefit of those of you who may not have as much of a detailed knowledge of the workings of a DTA. Now, DTA, the proper terminology is a DTAA, standing for a double taxation avoidance agreement, although we try not to pronounce the A, which stands for avoidance, so we just call it a double taxation agreement. And what is a double taxation agreement? Well, it is an agreement which attempts to eliminate or reduce the unfair burden of double taxation on the same income. Now, those of you who are in business would know that it is not unusual for a business or an individual as well who is resident in one country to make a taxable gain in another. That person may find that he is obliged by domestic laws to pay tax on that gain locally, and also pay tax again in the country in which the gain was made, thus leading him to suffer from double taxation. Because this is inequitable and may discourage cross-border investments, many nations make bilateral double taxation agreements with each other. So DTAs are such agreements which aim at reducing or eliminating that unfair burden that I referred to earlier on, so that there is no double taxation on the same income and for identical or overlapping periods due to certain connected factors. Now, in addition to the elimination of double taxation, DTAs can also reduce the headline tax applicable in the contracting state, and sometimes also achieves double non-taxation, which is one of the things that has been criticized by international organizations. And as some of you would know, the BEPS project of the OECD is aimed at eliminating double non-taxation. So what are the key components of a DTA? Well, there are effectively three main components. A DTA will look at defining the source of the various income, so through the use of what is called source rules. Then there would be assignment rules that would allocate the taxing rights to one or to both states. And then there will be relief rules that will eliminate or relieve juridical double taxation. So that's what basically a DTA is. There are different models of treaties. Typically, there are two that are mostly utilized, which are the OECD model. It's often used as a starting point. The United Nations also has its own model tax convention, but all Mauritian double taxation avoidance treaties are based on the OECD model.
Kenya first signed a double tax treaty with Mauritius back in 2012. The 2012 DTA was subsequently ratified in 2014, and it was expected that it would come into force in January 2015. However, the Kenyan government did not notify the Mauritian government with respect to the completion of the ratification process, and therefore that DTA never came into force. Between that period, there was an intervening event. The intervening event was that one of the international organizations that is based out of Kenya, known as the Tax Justice Network, went to the High Court. And their key question to the High Court with respect to the Kenya-Mauritius Double Tax Treaty was whether sufficient public participation had occurred and whether parliamentary scrutiny of the Double Tax Treaty had been properly undertaken in accordance with the provisions of the Statutory Instruments Act. In brief, the Statutory Instruments Act, in particular Section 11, requires that every instrument that is going to have force of law be laid before Parliament within a period of 7 days from the date of which it is published. The case as it stood at the time was that, notwithstanding the fact that in 2014, the earlier Double Tax Treaty had been published in law, it had not been laid before Parliament within that period of time. Therefore, the finding of the High Court in the case where the petitioner was in fact Tax Justice Network was that the finding was that the original Double Tax Treaty, which had been signed in 2012, was not valid and therefore was nullified. The Kenyan government subsequently, together with the Mauritian government, began engaging in new discussions. And in April 2019, Kenya signed a new Double Tax Treaty, which was then subsequently published by Legal Notice 108 of 2020. This was then subsequently revoked and replaced with a new Double Tax Treaty, which was published by way of Legal Notice number 114 of 2020. The new Legal Notice number 114 of 2020 was to review the Double Tax Treaty. What in fact it did is that in the intervening period, the Kenyan government had negotiated a protocol with the Mauritian government, and the terms of the protocol were then incorporated into the new legal notice that was published towards the end of June 2020. In effect, this new legal notice, number 114 of 2020, was required to be laid before Parliament so that it could then commence a process as set out in the Statutory Instruments Act. Our understanding is that it was laid before Parliament on the 2nd of July 2020, which was within the timeline that is required under the provisions of Kenyan law for it to have force of law or for it to meet the requirements under the Statutory Instruments Act. Having said that, the fact that the legal notice has been published, and also given the fact that the legal notice has actually been laid before Parliament, does not automatically mean that the Double Tax Treaty enters into force. As has been already indicated by Assad, there is a requirement under the provisions of Article 28 of the Double Tax Treaty, which dictate what the provisions and the measures should be. Key issue is that upon that each contracting party should notify the other of the completion of the requirements required by law for entering into force of the agreement. Upon completion of the notifications in each country, then it shall enter into force on the first day of January in the year following the year in which those activities are completed. From a Kenyan perspective, the first thing is always that the legal notice needs to be published. As indicated, that has already occurred on 30th of June. Therefore, the process in terms of the notification is what we understand is currently ongoing. As of this moment, I am not aware of the completion of those mechanisms. And as Assad has also indicated, the Mauritian authorities have not received the notification from the Kenyan authorities. To the extent that that notification is completed between now and the end of this year, it will mean that the Double Tax Treaty will enter into force effective 1st of January 2020. Looking at everything that has happened. So, sorry, 1st of January 2021. Thank you, Hassan. To make this DTA effective, and we believe that that is going to happen very soon. Just in terms of the overall features of the DTA, the one thing to bear in mind with respect to a DTA is that the provisions of our Income Tax Act, specifically Section 41, indicate quite clearly that notwithstanding any provision in our law, the provisions of the DTA will have an overriding effect. Therefore, if there is a rate that is prescribed in the double tax treaty, the rate in the double tax treaty will have an overriding effect with respect to what the domestic legislation will provide for. Now, this is particularly important with respect to a number of features. Many of you are aware that in the course of this year, the withholding tax rate on dividends, where the dividends are being paid to an unresident person, the rate has actually been increased from 10% to 15%. This increase would mean that when you pay a dividend from a Kenyan company to an unresident entity, the rate that will be applicable in the absence of a double tax treaty will be 15%. Under the Kenya-Mauritius DTA, this rate would be reduced to 8%, provided that the DTA applies to your circumstances. That proviso we will deal with in a short while when we come to that issue as to the applicability of the DTA. With respect to interest, similarly, the DTA between Kenya and Mauritius offers a preferential rate of 10% as compared to a rate of 15% in domestic legislation. The same case with royalties, a preferential rate of 12% where the DTA applies as compared to 20%. And with technical fees, and technical fees have been given the definition to mean any payment in consideration of any service of a managerial, technical, or consultancy nature, the rate is 10% as compared to 20% under domestic legislation. Turning now to the question of capital gains tax. As you all know, in Kenya, capital gains tax was introduced on 1st of January 2015, and the rate that has been prescribed at the moment is 5%. There has been talk in the past of increasing this rate from 5% to 12.5%, and it may very, very well be the case that in the future this rate will increase, although presently it's 5% at the moment. Domestically, sale of shares of a Kenyan company would trigger 5% CGT on the gain made. Where the double tax treaty between Kenya and Mauritius applies, there is a specific provision that needs to be considered. And essentially what it provides for is that CGT will only be applicable in respect of what's considered to be a property-rich entity. A property-rich entity is where the company holds at least 50% of its value is derived from the immovable property situated in Kenya. And there is a mechanism now for computing it, being the value within the 365 days preceding the disposal. And the person disposing the shares holds at least 50% of the capital, directly or indirectly, within that period in respect of that disposal. Where, for example, the entity is different in the sense that the entity is one that does not hold underlying property, and the sale of the shares is then sold. In effect, what that therefore means is that the CGT shield may be applicable provided that the DTA is in force, or is in force, and also that it is applicable to your circumstances. Now, in reality, I am only highlighting in those 5 minutes the most salient features of the double tax treaty. There are a number of cross-cutting things to think about. For example, the DTA talks about how to deal with permanent establishments, how to deal with issues to do with business profits, and a number of other far-reaching provisions that would be of relevance and which we would be very happy to advise in due course. But that is really a summary of the features. Is that they are not meant to facilitate circumstances where someone could take a benefit of the DTA, which they're not entitled to. So under the provisions of the DTA itself, there is a requirement that anyone who seeks to take the benefit under the double tax treaty must be the beneficial owner of that income. And this cuts across all the aspects that I've talked to, the dividends. I've also talked about the interest, royalties, and in every sense, each of those categories, that you can only benefit under the double tax treaty if you're the beneficial owner of that income. Now, the second aspect is that domestically in the Kenyan domestic legislation, there is a provision that has been introduced in section 41, subsection 5, and subsection 6 of our domestic law. What this provision essentially provides for is that provided that the company in Mauritius is not at least 50% owned by resident persons, and it talks about the underlying ownership is not at least 50% held by Mauritian residents, then the benefit is not available. Now, there are a number of things to think through carefully. What does underlying ownership mean? But on the face of it, for example, if a Kenyan national or a Kenyan resident sets up an entity in Mauritius, on the face of it, the DTA will not be applicable unless at least 50% of the ownership of the Mauritian entity is owned by Mauritian residents. Now, there is an exception to that rule, and this exception is where that entity in Mauritius is listed. So to the extent that it is a listed entity, then that provision would not, or that restriction would not apply.
You made certain introductory remarks which are very pertinent in the circumstances. So basically, as you mentioned, on the website of the Mauritius tax authorities is mentioned that we're awaiting notification from Kenya. So as matters stands today in Mauritius, all procedures have already been completed by the Mauritian authorities for the treaty to come into force. So the treaty was gazetted in Mauritius on 10th of December 2019, and subsequently the Mauritian authorities have already notified their Kenyan counterparts about the completion of procedures in Mauritius. So for Mauritius, if I would say, it's all done, and we are essentially awaiting for the Kenyan authorities to counter notify Mauritius about the completion of procedures. So as Daniel rightly mentioned earlier, Article 28 of the DTA provides that the DTA will become into force on the later of the two notifications. So effectively, if we assume that the Kenyan authorities file the notification with Mauritius at any point in time between now and 31st of December 2020, then the provisions of the DTA will start applying with effect from 1st of January 2021. So essentially, it's the 1st January following the later notification received by either Mauritius or Kenya. So this is where we are today on the status of the treaty, and we hope the procedures are completed soon. So we are going to sort of focus on the restrictions, or rather the parameters set out in the provisions of the DTA for benefiting of the treaty. Now, just like under the provisions of any OECD model treaty for that matter, the provisions of the Kenya-Mauritius DTA are normally applicable to residents, i.e. tax residents of either contracting state, so either Kenya or Mauritius, right? So means is effectively any Kenyan or any resident of a contracting state, and I'll take, for the purpose of discussion, I'll take the perspective of a Mauritian resident investing or doing business in Kenya. So in the context of a Mauritius person or Mauritius entity, it would mean, pursuant to the provisions of the treaty, that a person who is liable to tax in Mauritius by virtue of either having its domicile in Mauritius, or its residence in Mauritius, or its place of incorporation, or alternatively, its place of management. So if a Mauritius person qualifies in either of these four categories, then it should normally qualify for treaty benefits. Now, I say should normally, because obviously there are certain restrictions which I'm going to cover. So first of all, the treaty specifically excludes from the definition of resident any person who might meet one of those four conditions which I mentioned, but is only liable to tax in Mauritius in respect of income derived from sources within Mauritius. Right, so if I apply this very practically for those who understand the Mauritian jurisdiction, so if we were to have the like of an authorized company, which would technically meet one of those conditions by virtue of it being incorporated in Mauritius and technically being able to tax in Mauritius, right, one might infer as to whether an authorized company would be able to get benefit under the treaty. However, that exclusion means that if a company is only liable to tax in Mauritius on income being sourced in Mauritius, then it's not entitled to the treaty benefits. It's because it does not qualify as a resident of Mauritius, which is the case for authorized companies, which are only subject to tax in Mauritius on Mauritius source income. So that's by way of an example. So this is one exclusion, which is with respect to the liability to tax, has to be a liability to tax per se, and not a liability to tax which is restricted to source basis of taxation. Now, then we also have situations where a person may be deemed to be resident in both contracting states, in both countries, right? So for example, you can have a person or a company that is incorporated in Mauritius, but which is managed or controlled out of Kenya, if I take that example. So in that case, there is a provision of the treaty which says that if there is a resident, a person that is resident in both contracting states, i.e. both of Kenya and Mauritius, then it will be deemed to be resident in the country where its place of effective management lies. And place of effective management has been defined in the treaty itself to mean the place where strategic management and commercial decisions that are necessary for the conduct of the entity's business as a whole are in substance made. So effectively, it means where the entity is being effectively managed, where the decisions are being taken, not necessarily only strategic decisions, but strategic and commercial decisions, so the day-to-day management. So in those cases, if there is some kind of confusion as to what should be the residence status of a person for the purposes of that treaty, we would have recourse to the status of place of effective management. Now, if an entity qualifies as a resident of Mauritius, is fully liable to tax in Mauritius, and is not deemed to be resident in another country, or Kenya for that matter, then normally it should have entitlement to the treaty benefits. But notwithstanding that, I think it's important that we mention that the treaty contains certain limitations of benefits. Right? So what these are effectively conditions which are very much consistent with OECD's multilateral instrument that have been introduced in the treaty itself. So what effectively it implies in the mains, first of all, the treaty includes what we call a principal purpose test. So effectively, it says that if a person is deriving treaty benefit and it is established that the transaction or the arrangement that was carried out was principally, so one of the principal purposes of that transaction was to obtain the benefit under the treaty, right? Then normally the treaty benefit would be denied unless it can be established that granting that benefit was in accordance with the objective and the purpose of that treaty. So in short, if a Mauritian resident carries out a transaction and it is established by the Kenyan authorities that one of the principal purposes was for the obtaining of the tax benefit, then they could deny the treaty benefit and the benefits under the treaty. So what I will cover is effectively what should be the end result in Mauritius if someone uses Mauritius as an entitled to the treaty benefits. Now, short form answer, and I'm going in view of the shortage of time, so I'm going to cover the main income streams that was also covered by Daniel. So as regards dividend income, if we have a Mauritian resident that owns more than 5% shareholding in a Kenyan investee company, right, in the light of the application of the foreign tax credit provisions under Article 22 of the treaty and the provisions for the foreign tax credit legislation under domestic law in Mauritius, we should not expect any further residual tax liability in Mauritius on dividend income, which should result in a tax saving of 7% compared to what would have applied in the absence of the tax treaty. That is in relation to interest, to dividend. Now, coming to interest, obviously, there is a reduced withholding tax rate of 10%, which applies under the Kenyan Mauritius DTA. But in Mauritius, the interest income would be taxable at 15%, but may be subject to an partial exemption if substance conditions are met. Therefore, we expect to have a residual tax liability of 3% in Mauritius. That would still leave us with a net tax saving of 2% on the interest income as compared to the situation without the treaty. Having said this, if a company is investing into Kenya by way of both equity and debt, and therefore in any income year receives both dividend and interest income, we would expect that there would be excess foreign tax credits on the dividend that we can apply to the residual tax in Mauritius on interest income, and therefore the tax savings above the 2% which I just mentioned. So that's for dividend interest. Capital gains, that's easy. I think Dalian has covered it very comprehensively. The only thing I would add from a Mauritius perspective is if a Mauritian resident holds less than 50% shareholding in the Kenyan investee, on the assumption that it is not property rich, then it would have access normally to benefits under the treaty. And in Mauritius, gains from the disposal of shares and securities are exempt, so there would not be any residual tax liability in Mauritius. Similarly, for royalties, we mentioned that the domestic tax rate of 20% may be reduced to 12% under the treaty. In Mauritius, there would be an additional 3% tax to bring it to 15%, which would mean a tax saving of 5% on the royalty income. And there would be also a similar 5% tax savings for technical services rendered by a Mauritian resident into Kenya, on the assumption that the services provided are not provided on site in Kenya and therefore does not constitute a permanent establishment in Kenya, depending on the amount of time spent in Kenya. So that's in a nutshell, within the short span of time, Asad, the Mauritian implications.
And I just thought that for the purposes of this discussion, I'll focus on the residency of companies primarily, because they are the most utilized vehicles in the context of international business activities. Now, under Section 73 of the Mauritian Income Tax Act, resident in respect of an income year, when it applies to a company, means a company which is either incorporated in Mauritius or has its central management and control in Mauritius. It's also important to highlight that under Section 73, capital A subsection 1, it is provided that notwithstanding Section 73, i.e. the section I just referred to, a company that is incorporated in Mauritius shall be treated as resident if it is centrally managed and controlled outside of Mauritius. Therefore, if we apply these two sections, it effectively means that a company which is incorporated in Mauritius will be deemed to be tax resident in Mauritius for the purposes of Mauritian tax laws, unless it is centrally managed and controlled outside of Mauritius. I would just also like to add that if the company is structured as a global business company, as you know, Mauritius has two types of companies, or we could even go to three, but the third one is not as relevant because it's the authorized company. The two that are mostly relevant for treaty purposes is the domestic company and the global business company. And if the company is structured as a global business company, then there are some additional requirements that need to be complied with before that company would be issued with a tax residency certificate. In particular, there are three core requirements under the law for a GBC to be provided with a tax residency certificate, and these are that it must carry out its core income generating activities in or from Mauritius. It must be centrally managed and controlled from Mauritius, and it must be administered by a management company such as Axis. Now, the difference between a domestic company and a global business company is essentially in respect of whether that company has got any foreign ownership and whether that company is conducting local or global business. Now, if a company is established in Mauritius to conduct business outside of Mauritius, and the ownership of that company is foreign, majoritarily foreign, i.e. more than 50% of the ownership is foreign, then it must be structured as a global business company. So a global business company, subject to complying with these three core conditions I mentioned, core income generating activities, management and control, administered by a management company, would then be considered to be tax resident in Mauritius and would get a tax residency certificate and would therefore be able to benefit from the treaty. A domestic company would, by virtue of the fact that it is incorporated and provided it's not centrally managed and controlled outside of Mauritius, would be deemed to be resident in Mauritius, but it would also, if it wants to avail of the partial exemption system that Akshaw alluded to earlier on, it will also need to demonstrate that it is carrying out its core income generating activity in or from Mauritius. I would have wanted to say more on
to exchange of information within the DTA. Now, it is very much in the model of the OECD model, and this provides, now the main provision provides the competent authorities of the contracting state shall exchange such information as is foreseeably relevant for the carrying out of a provision of this agreement or the administration or enforcement of the domestic laws concerning taxes of every kind and description imposed on behalf of the contracting state, insofar as the taxation thereunder is not contrary to this agreement. The exchange of information is not restricted by Articles 1 and 2. So the important element in this is that it provides, number one, that the taxes which is, with a standard which is relevant, is that it must be foreseeably relevant for the collection of taxes. So therefore, there is a sort of limiting factor, but the limiting factor is that of foreseeable, it must be foreseeably relevant for the collection of taxes, right? So it cannot be any information. Authorities cannot go on a fishing expedition to get information which is not relevant to the collection of taxation. So that's the first issue, which is very important. However, it is extremely wide, so it doesn't concern only taxes covered by the DTA. So it may cover indirect taxation, it may cover taxation of any kind. In addition, the exchange of information is not restricted by Article 1 and 2. And what does that mean? Is that even if the exchange of information applies to someone who is not resident in either state. So, for instance, if you have a third party who effectively, say, a UK national who has an income in Mauritius and in Kenya, therefore the Kenyan authorities may seek to know information in respect of that person in Mauritius in respect of their taxes. So that's an important issue. The other issue which must be said is that, however, this is subject obviously to the general rules and the legal provisions regarding the rights of defendants and witnesses in judicial proceedings. So the right of not to self-incriminate and so on and so forth. Now, the other issue which is quite important in this matter is that it must be, there are some restrictions in as much as it must be for the purposes of, so there must be some reciprocity between the two states. So effectively, you cannot ask for, one state cannot ask for information which it would not have been available in its own jurisdiction. So there is a request for reciprocity between the two countries. There is also an important issue, is that another limitation which is quite important is that it regards trade secrets and so on. So effectively, if a tax authority is asking information to another tax authority, so the Mauritian authority asking, say, information in respect of a taxpayer in Kenya, and it goes beyond issues regarding to tax, and is asking more information which is commercially sensitive, then obviously this type of information should not be provided by the other contracting state. However, obviously under the common reporting standard, there is an automatic exchange of information, but this is wholly different, right? Yeah. This regards information regarding, so the types of information which is provided is what would be usually provided in the administration of the tax affairs of a taxpayer. So for instance, you would be able to ask for all the revenues, for instance, the tax returns of this taxpayer in respect of the other contracting state, the book and records, certain books and records, whatever would usually be asked by a revenue authority of its taxpayer can be requested, right? So that's usually what is provided, and it can also not be specific to a taxpayer, right? So it can be information regarding I don't know, nationals of that others of one contracting state asking general information regarding the payment of or statistical information regarding nationals of its own state paying taxes in that other state, and so on. In respect of in one country is not enforceable in another jurisdiction. So that's the accepted rules of international law. However, the OECD model changed in I think it's 2003 to include a provision in the DTA, in the model DTA, which is headed assistance in collection of taxation, which effectively reverses this international rule, this international tax rule. Now, effectively, what it does, and this provision is included in the double taxation treaty between Mauritius and Kenya, which is for me, which is actually the first time I think it is included in any of the double taxation treaties entered into by Mauritius. Now, this, I haven't seen it elsewhere. Now, this provides, right, under paragraph 1, that the contracting states undertakes to lend assistance to each other in the collection of revenue claims. Now, this assistance is not limited, right, to residents of either contracting state. Again, very wide. Or by taxes covered by the DTA. Thus, if a resident of a third state owes tax to the requesting state and has assets located in the requested state, the requested state undertakes to provide provision in the collection of those revenue claims. So it's extremely wide and extremely, now even more so, right? It's even wider than this, but under paragraph 4, right, of Article 27, right, this provides that under the internal law, states may provide provisions for assets to be frozen or seized, right, in order to ensure that they are available to satisfy an eventual revenue claim, even though the revenue claim is not itself immediately enforceable. So you can go and seek, if one state can go and seek a freezing order in that other state, right, to freeze bank accounts and so on, pending the determination of a revenue claim. Obviously, there are some certain safeguards in respect of time limits and so on and so forth, and rules of reciprocity as well. But this is for me a significant shift in the ability of foreign states to enforce tax debts, which otherwise is not available through international tax laws.
What we would anticipate is investment structures, so investments by way of equity into a Kenyan company through a Mauritian resident company. As both Aksha and Daniel mentioned, under the DTA, dividends that would be paid by the Kenyan company to the Mauritian resident company would not be subject to more than 8% of the gross amount of the dividends. Secondly, I can think of investments by way of debt into a Kenyan company through a Mauritian resident company. Again, under the DTA, interests which are paid from Kenya to Mauritius will not be subject to more than 10% of the gross amount of the interest. I can also think of the use of a Mauritian resident company to hold IP rights, because under the DTA, royalties that are paid from Kenya to Mauritius will not be subject to more than 12% of the gross amount of the royalties. And obviously, last but not least, and both Daniel and Aksha have alluded to that, in the context of mitigation of capital gains tax, disposal of Kenyan assets by a Mauritian resident company, other than certain exceptions, such as immovable property is excluded from the ambit of that section. Certain movable property are also excluded. Alienation of ships or aircrafts and a few other exceptions are not subject to this capital gain tax provision. But other than that, a disposal of a Kenyan asset by a Mauritian resident company will only be taxable in the contracting state where the alienator is resident, which would be Mauritius, in the case where the assets are held by a Mauritian company. And as Mauritius does not tax gains, the transaction would be free from capital gains tax. So these are a few potential structuring options, but with a caveat, of course. And my friends have talked a lot about it, and there are also going to be, I've seen the questions, a lot of questions about beneficial ownership. The caveat, of course, is that the above structuring options would only be possible if 50% or more of the underlying ownership of the Mauritian company is held by an individual or individuals who are residents or one sort of who are residents of Mauritius. So if you have more than 50% of the underlying ownership,